All right, everyone, it is 5:30, so I'd like to call to order this special meeting of the Fargo Board of Education. The purposes of our meeting is to hear a Level 3 grievance brought to us through the FEA and described in memo number 43. I would look for an approval of our agenda. Yes, Jim?
I move adoption of the agenda as provided.
Second.
Thank you. Moved by Jim and seconded by Tracy. Any discussion? All right, thank you. All in favor, please say yes.
Yes.
Any opposed, same sign. Thank you so much. The motion to approve the agenda has passed. All right, we'll move on to item number 4, the addressing of the Level 3 grievance. What I'm going to propose is that the FEA begins and you'll start and present your grievance. Fargo Public Schools will have an opportunity to respond to that. You will have another opportunity to reply, and then the board, I'd ask that you wait until those 3 steps have happened before you start asking questions to make sure that they can deliver everything they'd like to. So with that, whoever is going to be your spokesperson, I'd invite you to the podium.
Madam President.
There we go.
There we go. Okay. Madam President, members of the Fargo School Board, my name is Mike Eierman. I'm NDEA General Counsel. I've been asked by the Fargo Education Association to present this grievance to you. To my understanding, you already have the grievance documents, some contract documents. So I'm not going to spend a lot of time necessarily on that. I don't think that's necessarily what the issue is. I think the issue as it boils down with the FEA and the dispute with the Fargo School District is whether or not the school district has the authority to hire an independent contractor to contract for a special education position. Those facts are not in dispute. Like I said, I'm not going to spend a lot of time talking about those. So what I'd like to do is ironically start at the beginning. But the beginning is not in July of 2023 when this contract was contemplated and issued, subsequently in August of 2023. The start of this entire case goes back to 1969. 1969, right after the Minot flood and the Minot teachers went out on strike, the legislature just happened to be in session. And at that particular time, the legislature, seeing that the Minot School District had fired over 100 teachers and the Minot School was out on strike, decided that it was time, and the time and the place presented itself where the state of North Dakota then, through the legislature, passed a negotiation statute. So the negotiation statute, the entire chapter has been in place since 1969. In 1969, when they passed the teacher negotiations law, the legislature declared that it was essential to the welfare of its people to establish a policy to promote the improvement of personnel management and relations between school boards and their certificated employees by providing a uniform basis for recognizing the right of public certificated employees to join organizations of their own choice and be represented by such organizations in their professional employment relationship with the public school districts of the state of North Dakota. That was the purpose of the 1969 statute, to improve personnel management relations between school boards and teachers. In 2001, the statute went through a rewrite. The legislature went through, and on occasion they will rewrite the statutes. But the intent that was formulated in 1969 did not change. It was the same intent, even though some of the words may have changed. And the reason we know that is because the Supreme Court said so in a case called Kenmere Education Association in 2006. So for the last 54 years in the state of North Dakota, school districts have negotiated with teachers. And in this particular instance, there was an organization called the Fargo Education Association. And in the last 54 years, your school board has negotiated with the Fargo Education Association for the terms and conditions for their employees who are certificated and who are members or are covered by the FEA agreement. In order to do that, in order to be recognized as the Fargo Education Association, and I can't give you a number as to how many times you've negotiated with the Fargo Education Association, because there have been a couple of 2-year contracts in some of those, but let's say there's 45 or 50 different times where the FEA has petitioned to be recognized as the exclusive bargaining representative for the certificated staff and the teachers in the Fargo School District. And that has always been approved by the board. The board and the administration are well aware of the steps that must be followed by a group of teachers that want to negotiate with the board concerning the terms and conditions of employment. There is no dispute that the FEA has followed all of the steps and has been recognized by the board. And this is important. And you can look in your packet because in the grievance document that the FEA filed, they put in Article 1 of their negotiated agreement in which they are the exclusive, the word is exclusive, bargaining representative for the teachers. See Article 1 of the negotiated agreement. So in order for the Fargo Education Association to get to that point, there are steps in the law that they have to go through, and I'm not going to spend a lot of time talking about that. This board has consistently recognized the FEA as the authority. In contrast to that now, this summer, the school district got into a contract with Full Circle Pediatric Services. Full Circle didn't comply with any of the statutory requirements to petition the board to be recognized as a bargaining unit for any of the teachers. And the importance of that is that when an organization such as the FEA gets recognized by the board as the exclusive representative, they are recognized, the statute says the law in the state of North Dakota is a representative organization, which would be the Fargo Education Association, that enters a contract with the board of a school district to represent the negotiating unit for the duration of the contract or until another representative organization is recognized by the board of the school district as its representative. And that's under North Dakota Century Code Section 15.1, 1611. Now, this grievance has gone through, and now we are at level 3, and now we're in front of the board. And it's my understanding, I received late Saturday night at about midnight a copy of a packet which was given to you, which also included a memorandum from Superintendent Gandhi, attorneys Brandner and Thompson in regards to this level 3 grievance. What I'd like to start off with this is my timeline. It may not necessarily agree with your timeline, but this is my timeline. On July 11th, the Fargo School Board awards bids for a special education teacher for level C self-contained classroom. On the 25th of July, the FEA files the grievance, and you have those grievance documents in there, and they have cited about 4 or 5 different provisions of the negotiated agreement which they contend were violated. And under your grievance procedure, I think most of the time, and in most grievance procedures, it's a situation in which you bring out the violations of the contract and not necessarily the violations of the law, because there's a couple of those that I'll talk about as well. On August 2nd, I had conversations with Mr. Thompson. I've had dealings with Mr. Thompson over the years, and he and I know each other very well. And we talked about the upcoming level 2 grievance meeting that was going to be held the next day. On August 3rd, FEA grievance meeting with the Fargo School Administration. And we discussed this matter. And according to the memo that was provided to you by the superintendent and your attorneys, we almost settled it, and we did. We came very close to settling this. And the premise upon which we almost settled was, and there will be a dispute, and your lawyers can tell you their version, and I'll tell you my version. We understand that with this particular classroom, it is very difficult to get a teacher. Nobody knows more than the NDU, more than North Dakota United, how difficult it is to get teachers, because we represent about 85% of them in the state. So we know how difficult it is. And in doing so, we talked about the fact that under these unique circumstances, the FEA would agree that we will leave this contract, because by this time the bids were already out. There was a contractual relationship going to happen between the school district and Full Circle, and we were willing to let that go for this year, And the premise of our position was, we don't ever want to do this again. We never want to do this again. You will issue contracts pursuant to that negotiated agreement. You now issued a contract off of the negotiated agreement. You individually bargained with another entity, and you'll hear that, well, we didn't really contract with a teacher, we contracted with a company to get a teacher. That's a hair that I'm not going to split. You contracted with somebody besides the FEA who's the exclusive bargaining unit. They're it. And during that discussion, we agreed to that, but the premise of my argument to your school administration is, I don't want to do this again. I'm not coming back down to Fargo to argue with you and your school board over issuing contracts off of the negotiated agreement. Mr. Thompson offered to write a settlement letter, and I said, great, have at it. Send it to me and I'll look at it. And on August 16th, Mr. Thompson provided me a letter, and according to my timeline, I called him the next day and I said, well, there's some things that have to be changed in that letter. I wasn't satisfied with the original letter. On August 17th, he sent me a second letter, which was slightly revised, and Mr. Thompson also provided me with a arbitration decision that he had been in, because one of the things that we were concerned about was whether or not, because apparently this happened last year without the FEA knowing it, and we were concerned about the precedent that might set. So there was discussions in there about a non-precedential agreement, but the premise that I was going forward is, I don't want to do this again. I'm not going to give you carte blanche to start issuing contracts off of our contract. So on August 18th, I met with the FEA Executive Committee, and at that particular time, I was informed that, and it's mentioned in your memo from your attorneys and your superintendent, that there was a dispute in regards to the school psychologist, which is another grievance which is in the mix, and we expect a response to the level 2 either today or tomorrow. We had now found out that the school psychs contracts were now, which were always issued on the teacher contract, were now being issued off the teacher contract, which is exactly what I told them I was not going to allow them to do. I had a discussion with Mr. Thompson on the 18th, and I told him the deal was off. And we'll move and I'll let the FEA decide if they want to move the grievance up, and they did. I'm sorry, that was not on the 18th, that was on the 21st. And then on August 28th, we notified the school board that we're going to proceed to level 3. So we're here today because, and I've reviewed your lawyers and your superintendent's memo, and I'll let them speak to it, and then I'll respond to it. I don't want to speak out of turn. Our premise is this, it's very simple. Since 1969, the legislature created a system whereby school boards and teachers can negotiate. And your school board has gone a step further because there are some arguments about exclusive. There's no argument about that in Fargo. It's in the negotiated agreement. The word is used as exclusive. So the issue becomes, well, we've got this hard position to fill. And the answer by the Fargo School Administration is we're going to break the contract to the FEA and we're going to go out and hire an independent contractor who then goes and hires a teacher for this position. Okay? But in North Dakota, you know, that isn't necessarily how it's done. Okay, so let me go back to my timeline. 1969, the law is created. School districts and education associations negotiate, and there's all sorts of lawsuits about timeframes and all the rest of it. They were down in Edgeley and they were out in Dickinson and all the rest of it, and I handled a couple of those, but most of those were way before my time. Then in 2002, there was a case involving a school counselor by the name of Dale Hilton. The Center Education Association, it issued a contract to him off the schedule, and his argument was, I'm not covered by the Center Education Association agreement, so I can negotiate my own contract. I represented the Center Education Association back in 1999 when they sued the Center School District, and we settled that, and the settlement was, and the school district was represented by Gary Thune. The settlement was, we'll put Dale Hilton's contract back on the schedule to comply with the negotiated agreement. Several months after that, Dale Hilton sued the North Dakota Education Association and sued the Center Education Association and sued the 20 members of the Center Education Association for breach of contract and all these other different claims. In 2002, the North Dakota Supreme Court ruled in favor of the NDEA and the CEA and the individual members and held that counselors were certificated teachers under the North Dakota law. And since Hilton was a counselor and he was considered a teacher under the law, his contract had to be issued pursuant to the negotiated agreement. 4 years later, a situation developed in Kenmare. Kenmare couldn't find or couldn't hire a speech language pathologist. They had one through a special ed unit, but they thought it was costing them too much money, so they wanted to do it. And they proposed language in their negotiations between themselves and the Kenmare Education Association. They proposed language which would allow them to pay off of the schedule. And the KEA fought them with that. And it ends up in the Supreme Court. And then the Supreme Court sided with the Kenmare School District and said that they could bargain, the Kenmare School District could bargain paying somebody off the schedule because it wasn't in North Dakota law at the time. That's in 2006. In 2007, the legislature now starts to consider bills which will allow school districts to pay off of the schedule for what is called an unfillable position in 2007. I went in on behalf of the NDEA at the time and opposed that legislation because I thought it was a bad idea. I thought it was going to destroy negotiated agreements. And so what the legislature did is they set up a process by which school districts can go in, show the Department of Public Instruction that they have an unfillable position and get the consent of DPI to pay off of the schedule in 2007. And us who represent teachers and are involved with teachers thought this was going to be the end of negotiations and the end of whatever, and it was a blip. School boards respected negotiated agreements, respected the bargaining process and all the rest of it, and there was not a flood of school districts who were paying off the schedule by going through this process. We thought the dam broke. It didn't. School boards and teachers sat down and they settled those agreements. In 2015, they changed the law. But since 2015, they haven't changed the law. But what it requires is if a school district has an unfillable position like you had this summer, you have the opportunity to go to the Department of Public Instruction, tell the superintendent of public instruction all of the measures that you've taken to fill that position, get her consent, and pay that teacher what the market required. That's the process you go through. Your school district didn't do that. So, as I was researching this and looking at it, you have a core principle. The core principle has been in place since 1969. You negotiate with the Education Association all of the terms and conditions of employment, and in this particular case, in order to hire a special education teacher, you have to comply with the contract, and you have to negotiate and contact the FEA to do it. The exception to that is if you've got an unfillable position. So the legislature passed a statute to deal with the exact situation that you faced this summer. You have an unfillable position, but the school administration disregarded that and just went out and hired somebody else. As I indicated, as I was researching this position, the FEA's position, and it occurred to me a couple nights ago, but then it occurred to me on the drive down, so it's not on your PowerPoint, but I'm going to hand it out to you. I was thinking, what does the NDSBA say about this? What does the North Dakota School Boards Association say about paying teachers off of the schedule? They've got a negotiations manual. I'm sure you've been to training. You used to go to listen to Gary Thune. You go to listen to maybe Mr. Thompson does it, or other people do it, or Amy DeCook does it now, or whoever it happens to be. But there's a manual they give you, and this is how you do it. Set it right down the line. So, on my way down today, I was wondering, what does NDSBA say about paying teachers off the schedule? I'll wait till everybody gets a copy of it. I think I made enough. I hope I made enough.
I can also, if it's on the website, I can pull it up. Okay.
Okay. So,
Is it a staple or
no, it's
it's just
this is one
page?
sheet.
Oh, well, then we have several.
You enough?
Plenty, thank you.
Okay. Okay, so I asked Mr. Marquardt, Mr. Kraft, if they would look for this, and they found it. So this is, I'm not so sure, I've been representing teachers since 1987. I don't know if I have ever sat in front of a school board and indicated to them that I think the school board association is right. Generally, it's not in my makeup to do that, because I don't do that. According to this, right out of your negotiations manual, there it is. Boards should be cautious in compensating teachers above or beyond what is provided in the negotiated agreement. State law, according to your school board association, state law authorizes certain payments to teachers in addition to the salary set forth in the negotiated agreement under the following limited circumstances. Number one, hard to fill positions. That's the unfillable position statute that the legislature created to deal with the situation that you faced. Number two, signing bonuses. You go down to the last paragraph in that section. If additional compensation is desired or needed in a particular situation, the board and the representative organization may need to negotiate a modification or addendum to the negotiated agreement. Subsection 18 provides that a representative organization, that's the Fargo Education Association, that enters into a contract with the board retains authority to represent the negotiating unit for the duration of the contract term or until another representative is recognized. So if the legislature creates this this scheme that has worked pretty well over the last 54 years about negotiations, and then all of a sudden in 2007 they tweak it to allow you to pay off of the schedule, and then they tweak it a little bit more in 2015 to allow you to pay off the schedule. Why in 2023 are we facing a situation in which the core principle has been disregarded? The addendums to the main law have been disregarded, and your school district goes out and hires a company to go hire a teacher to fill a classroom. That's the violation of the law. That's the violation of your contract. It's that simple. In the memo that was given to you by your superintendent and your attorney, they come up with different options. And one of the options was, well, we could have just transferred somebody, and they could have. And the second option they came up with was, well, we could have complied with that statute. Now, I've got this fancy PowerPoint, but I'm not going to use most of it because of the fact that I just want to show you something. What I'm going through here, you've got in your packet. You've got in your board packet. Okay? So, and there's Mr. Thompson's original letter to me. There's the contract. But this is what I really want to spend a couple of minutes looking at. I called up to DPI. Okay? And you need to understand that DPI is the agency that monitors school districts that want to pay off the schedule. Okay? When you look at the statute, it says, if a school district, if at the conclusion of the school calendar, the board of the school district has a teaching position vacant, and if the board, having done all things necessary and proper, is unable to fill that position by the 45th day, they shall notify the superintendent of public instruction. Okay? So if you've been reading the media and you know this, we're in a teacher hiring crisis right now. And I've been watching this for a long time, and I knew it was coming. And now it's here. And everybody's wringing their hands over it. We can't hire teachers. Well, things should have been done years ago, but that's another discussion. But here's the point. There is a process that's set up. Here, there's a letter to the superintendent of the Flasher School District allowing him to pay off of the schedule. He's been approved. Under the statute, he's been approved. Okay? There's another one. There's one to the superintendent of the Devil's Lake School. Ladies and gentlemen of the board, do you know how many school districts in the state of North Dakota petitioned the superintendent of public instruction to pay off of the schedule this year? 2. Flasher and Devil's Lake. There they are. That's it. Not Bismarck, not Dickinson, not Crosby, not anywhere else. Flasher and Devil's Lake. And for sure, not Fargo. All your administration had to do was to contact the Department of Public Instruction, satisfy their criteria, and they could have paid somebody off of the schedule higher amounts to get into that classroom, that level C classroom. They chose not to do it. What did they choose to do? They chose to violate the FEA contract. It's that simple. 2 school districts in the state of North Dakota in this tremendous hiring situation that we've got. 2. And Fargo wasn't one of them. I'm going to, as your president has indicated, it's somebody else's turn, and I'll come back and talk about their turn.
Thank you. Mr. Thompson.
Thank you. Thank you, Madam President and Council. My name is Seth Thompson. I'm here to present the district's position on the grievance here. I very much appreciate the opportunity to be here in person to deliver this. I do want to make one note. Some of you who know me probably know this. I've got a little bit of a hearing problem, so when we get to the question part a little bit later on, if I'm asking people to speak up, I'm not trying to be rude. I just sometimes have a little bit of a difficulty hearing. So I think I'm going to go back and I'm going to start a little bit back in history, but not quite to the extent that Mr. Geierman has. I'm going to go back, I think, to the August 3rd grievance meeting that the parties had. Mr. Geierman is right, indeed. The parties nearly resolved this grievance at that point because there was a recognition that at that point, the school year is right around the corner for actually starting. These are federally mandated services that have to be provided, and simply not providing these services was not an option. The grievance that the FEA had put forth had requested a remedy of actually rescinding the contract with Full Circle, which is not a viable option. So what the parties discussed was, let's do this. It makes sense to, yes, the FEA's objection to this at this point is noted. The district was not in agreement with the fact that whether there was or wasn't the authority to do that, that wasn't something that needed to be, whether it had the authority or didn't have the authority to do it, that wasn't something that needed to have a dispute over, because the parties had discussed, and in discussion with administration, it makes sense to have some discussions coming up in the fall, or coming up once the school year starts in the winter and the spring, to see if there were any potential other possibilities for filling this. And one of the points was that during our August 3rd meeting, the FEA had noted that they are the ones who may have some insight on some individuals who may be interested in a position like that, to which the response was, great, we'd love to hear that. At the end of the day, the administration very much wanted to get this position filled, and if it had the opportunity to fill it in-house, that was certainly a good, viable option. Candidly, I think that's still a viable option, because the reality of this grievance right now is there's no real remedy right now where a court or an arbitrator or anybody is going to respectfully unwind the providing of these services when they're required by federal and state law, and there's no way that we cannot provide these services to the students. So I wanted to just go back and make that point that I think we were on the finish line of this, and I think, you know, having further discussions on it as some possible options may make this a situation where it never does come up again if somebody can be found. But moving on from that, Mr. Geierman is right. This is an issue of authority. This is an issue of whether or not the district has the authority to enter into the agreement that it did, or whether, as Mr. Geierman has said, is whether it's something that has to be bargained. I think it's worth pointing out at this point that what this is not a fight over. This is not a fight over whether or not you have the authority to pay somebody over scale. Those statutes and cases, such as the Hilton case that Mr. Geierman was citing, the Kenmare case, and the subsequent statute that came out in 2007, those cases all specifically refer to and deal with public school teachers, public employees who are employed by the district. That's not the situation we're in here right now. Now, there were some other options that the district may have had the option to look at, namely the one statute that we had put in our memo and Mr. Geierman had put up. But I think the reality of it is, from a timing perspective, that really wasn't a viable option at the point in which the district went ahead with the full circle option right here. But just because the district had different options doesn't mean those were the only options it had to use. It's not uncommon, and it has happened a number of times over the years. I've got a document showing me at least 5 separate times in which the district has used the services of private contractors to provide, special education, or excuse me, to provide OT, school psychologist services, direct service provider for vacancies due to medical leaves and different things like that. And those are all situations that are a contractor being used to provide those services. The FEA doesn't negotiate those individuals' terms and conditions of employment or anything like that. And there are instances in which there were not grievances on any of those things. I do expect the response that the FEA is going to have is that, well, if we'd have known about those situations, we'd have probably done something or whatnot. I'll let Mr. Geierman address that. But the point is that there are other options that the district has for filling these types of positions. And it's worth noting, really, when you get down to the core of it, noting that this is a situation about whether or not the authority exists. We have to go back into the statute to see what authority the legislature has actually given education associations in North Dakota to collectively bargain. It's constrained, it's limited. They are limited to negotiating on behalf of teachers, and then there's, of course, a definition of teachers, and then also administrators. But it is for public school employees. It is explicitly listed to that. If you look at the authority for negotiating coming from the Century Code at 15.1-16-10, a group of teachers or group of administrators employed by the board of a public school district may form a negotiating entity. That does not give a broad enough reach to go out and dictate the terms and conditions of employment for a private party or for some other party. And I think, to me, when I'm thinking about this, there's a good way to make an analogy to that. If you think about it like this, in this state, we have special education units, which provide special education services to a host of districts. In those situations, those special education units will provide an employee hired by the special education unit to provide the services to a district, for example. What the FEA is asking for in this, and in that situation, that's using a private contractor, if you want to call it not a private contractor, but another entity to provide the services. But think about this. If the FEA is saying that that's something that needs to be negotiated, the FEA's position then is that it gets to negotiate the terms and conditions of employment for a separate entity, such as somebody employed by that special education unit, who may have their own collective bargaining rights, and they may have their own contract, for example, or an individual one. There's no way that the legislature's grant of authority goes so far as that they can dictate the terms and conditions of employment for those individuals. And the same thing is the truth with the private situation we have here. The FEA would be reaching out, trying to set the terms and conditions of employment for a private sector employee who may or may not have his or her own independent contract, who may actually have a union in his or her workplace under federal law. So the reaching out is something that I think it's a bridge too far. You know, there's a principle in the law that you can't do indirectly what you can't do it indirectly. You can't do it indirectly if you can't do it directly. I really butchered that, and I acknowledge that. The point being is if you don't have the authority to do something directly, you can't indirectly get to the same result. Well, that's really what's trying to go on here. The union is trying to actually reach out and control the district's ability to contract and provide services with other entities and other, providers and all of that. There's nothing in the Century Code or the contract, respectfully, that says that the district does not have the authority to do that. I understand the argument on being the exclusive bargaining agent, and what that's saying is, for the public school teachers, that's the bargaining agent. It's not saying that for some other group that the district decides to provide services with, that it has to bargain there. That's a big stretch for what the actual authority is. So at the end of the day, in a contract grievance, a union has an obligation to meet its burden of proof to show where the contract breach is and to also show a viable remedy. I think we've recognized that there's really no viable remedy here for the situation we're in right now. The remedy that's been asked is to rescind the contract. That's not a viable option. So at the end of the day, it doesn't make sense to do anything other than recognize the district has this authority here. There's no good option for the FEA in this situation outside of what has already been offered by the district to, let's talk about this. If we have the ability to fill this position in the future, if you've got some options for it, we'd love to hear that. And that is something that I think makes sense, but to find or to determine that the district doesn't have this authority is, I think, one, handcuffing it in a way that is detrimental, but two, I also think it expands the reach of the collective bargaining statute under North Dakota law, and I don't think that is appropriate and is what the legislature intended. So that's kind of a response on the position, the authority, and all of those sorts of things. I think Mr. Geierman is most certainly going to have some rebuttal, but I would obviously answer questions related to this when we get to that point.
Thank you. Mr. Geierman, I'd invite you back up.
There we go. Mr. Thompson has argued to you that there is no real remedy in this situation. I respectfully disagree with that. If you go into the contract, it's a 30-day contract. It's not a 193-day contract. It's 30 days. Because there's a provision in the contract that says either party can cancel the contract with 30 days notice. You cancel that contract tonight, you're out in 30 days. There is a remedy. Okay, you're not going to get sued for thousands and thousands and thousands of dollars because there's an out. It's in the contract. I'm not making that up. Is it required by federal law? Absolutely, it's required by federal law, but that's not what the issue is. And that isn't how you make decisions. There is no caveat that says you get to violate the collective bargaining agreement because the federal law allows you to do that. You've already talked about the options that you had and the options that you still have. And one of them is not violating the FEA agreement. So there is a real remedy, and we were just about on the finish line. We were. I was optimistic. I told the FEA, I think we're in pretty good shape here. Until I found out that 6 contracts for school sites got issued off of the contract. That's a deal breaker. I didn't know that when I talked to Mr. Thompson. As a matter of fact, on August 21st, when I called him, I said, what's the deal with these school site contracts? Because that throws a whole bunch of cold water on this whole thing. He indicated to me that he didn't do it, he didn't know about it, and that's fine. Mr. Thompson cited to you a legal maxim. The North Dakota Supreme Court has held on at least 6 different occasions, not necessarily in school cases, but this is the premise. It is a common maxim that the law does not permit by indirection what cannot be accomplished directly. And Mr. Thompson told you, you can't do something indirectly that you can't do directly. We should be able to agree on this point. You can't go and contract with a specific teacher today without going through the FEA and without going through that negotiated agreement, and the terms and conditions and the benefits and everything else are established by that negotiated agreement. You can't do that. I hope we're in agreement on that, because Dale Hilton tried to do that, the Center School District tried to do that, and they got sued and they lost. So if that's the direct action, you can't go out and contract specifically with a teacher unless you're going to comply with the FEA agreement. If the legal maxim is you can't do indirectly what you can't do directly, then you can't set up this straw man of we're not really contracting with a teacher, we're contracting with their employer. That's the indirection. If the School Boards Association really thought that you could subcontract claims out, they'd have put it in their negotiations manual. They tell you to be careful, and they suggest to you the 2 ways you get to do it. Or really the third way. This is a novel concept. Why don't you negotiate it with the FEA? You want to pay people off the schedule? Negotiate them with the FEA or comply with the schedule, or excuse me, comply with the statutes. If you can't directly negotiate individually and pay them a higher salary directly, you can't do it indirectly. Somebody else's bargaining rights? I'll answer the question. Pose the question. Who else has got bargaining rights besides FEA? In this school district, who else has bargaining rights but FEA? Nobody does. FEA does. Why? Why do they have this? Because you agreed to it. Look at your negotiated agreement. They are the exclusive bargaining. Exclusive bargaining. You agreed to it. Now, oh, we don't like that because we've got to comply with federal law or we can't find somebody or whatever. There are all sorts of mechanisms for you to deal with it, and you can get out of this contract in 30 days if you don't like it. If you go to full circle and say, you know what, we shouldn't have done this. Sorry, we shouldn't have done this. We violated the negotiated agreement we have at the FEA. Fargo School District is the only school district I know of in the state of North Dakota that has tried to subcontract with another teacher through another entity. Do you think the legislature, in creating this framework, tweaking it in 2007, tweaking it in 2015, were so stupid that they would allow school districts to just go around the whole process and do something else? Seriously? Do you really think that was the intent of the legislature? To give school boards, well, there's something else you can do. We're not going to put it in the law, but there's something else you can do. 54 years of history here, 54. And now all of a sudden we're coming in with this, well, we're not really contracting with a teacher. It kind of looks like that. Well, Full Circle is not providing anything except management. You got a teacher in there. When you hire teachers, you comply with the FEA agreement. It's that simple. Madam President, thank you.
Thank you. All right, I'd open it up to questions from the board. Or, yes?
Oh, I'm sorry, Madam Chairman. Just a couple of points, but I can wait and hit them after questions.
I hadn't contemplated a sir reply from you, but if you would like to, you can.
Okay. Just a couple points. Mr. Geierman has pointed out that, hey, that contract with Full Circle gives you a 30-day clause where you can terminate the contract with notice and all of that. That may be true, but the reality is there's no viable remedy here. So what would the point be of moving forward and terminating a contract for a service provider for federally and state mandated services that need to be provided when we couldn't find one searching in-house, searching outside, and all of those sorts of things before? It would make no sense. You know, the other point I would ask, it's more of a rhetorical question. What exactly did the FEA want? Did it want the administration to sit down and negotiate over the terms and conditions for this provider here? Because if you read the grievance, it isn't, the FEA's grievance isn't that the district went outside and used what it deems to be a subcontractor and all of that. It's that it didn't pay and didn't go in accordance with what the negotiated agreement was. If you read the grievance, that's what it's saying. So that's telling you right there that there's an agreement that they have, that you have the authority to do this sort of thing. It doesn't make sense to say that you can't do this here, but in the grievance to say, no, we should have negotiated over the amounts because it was different than what the pay was. You know, also the point of, you know, Mr. Geierman showing 2 letters of folks going to the state looking to pay over schedule. That isn't necessarily an acknowledgement that there are no other situations like you have going on, where districts have gone out to get different services provided through a different method. That's an acknowledgement that there were two districts that used the process in the statute. I think those are the main points I wanted to hit, if I could there. Thank you.
Jim, it looked like you had your hand. Did you have your hand up before? Oh, okay. All right. Any questions from board members? I think I saw Nikki first. Nikki?
Thank you. Curious, how long was this position listed for, that we did have no internal or external candidates for?
Madam President, may I answer that?
Yes.
So as of right now, it's 144 days.
Thank you.
Okay, Robin?
I respect both sides of this debate. I would say, Mr. Thompson, could you sum this up between two issues, third party versus direct employment? And then the school district could not find a direct employee. Is the confusion over the contracted employee? And is that the main conflict here?
I'm going to respectfully ask, could you speak up just a little bit?
Oh, I'm so
about that.
sorry. So I'm seeing two issues here that are rising to the top. I'm hearing third-party employees versus direct employment. And the school district could not find a direct employee. So in summation, is this really about a third-party employer versus a direct employer?
I think that is, a large part of the dispute right there. Because again, if you get back to the actual grievance, it's, the FEA is making the point that the terms and conditions for that outside group or whoever that was should have been negotiated. So, well, I think the FEA has a rub with the third party doing that. I don't think that from what I understand, is their deal breaker. I think they believe it should have been, whatever those terms and conditions for Full Circle should have been negotiated through the FEA, is how I understand it, which causes a bigger problem if you're going to bid that out. You would, it just causes an unworkable situation there.
Thank you.
Seth?
I have a question. And I don't know if, I'm sorry if this is
Real loud.
redundant to Robin's point, or if there's an answer within our packet that I'm not reading, and I apologize if that's the case, either or. In the in the memo from the 18th, from Dr. Gandhi and Tara and Seth, under number 2, the last sentence says Full Circle will employ and provide a qualified Full Circle employee to provide the services for the district. My question is, that teacher, who's the remitter of their pay?
Full Circle.
Okay. And then another question to just clarify, with this transaction, is this an award of a bid or a negotiation between the Fargo School District and Full Circle?
It was a bid,
Okay.
which, while I maybe inartfully stated, it was part of what I was trying to say in response to the other board member's question, that if you would have to negotiate with the union over what the pay is for that position, and then you'd also have to comply with the public bid statute and putting it out for bid, I don't see how that's workable.
I just wanted clarification. I wasn't trying to, if it was redundant, I apologize.
Madam President, it's only fair that if Mr. Thompson gets to respond, I get to respond. Isn't that fair?
I'll allow it. I don't know if it's only fair, but
Well,
you can, no, please, go ahead.
thank you. So if the concern is that we're contracting with an entity and we're not contracting with a teacher, right? Is that the big concern? Is that where you're drawing the
I'm
distinction?
not necessarily concerned. I just wanted point of clarification.
So let's go into the future. What happens next year after you settle your contracting? Well, we need to start paying math teachers 20 grand above the schedule. We're just going to go do that. And we're going to tell those 20 teachers, go out and create your own little corporation, and we'll just contract with your corporation, and then we'll pay math teachers 20 grand more than the schedule allows for. Do you understand what we're saying? Yeah. This is a very slippery slope, and we're not going to go down it. There are options, viable options. The reason this grievance is here is because the options that you had in May or June, or actually in April, May, June, July, or August, could have been taken. Now it's, well, we're sorry, but there's nothing we can do about it. This is the old permission forgiveness thing, right, that everybody jokes about. It's a lot easier to come and ask the FEA for forgiveness than it is to ask them for permission. Can we pay somebody off your schedule? You know what the answer would have been? Sure, you can pay somebody off our schedule if you comply with the statute and get the Department of Public Instruction involved. There's your answer. You could have done that in April. You could have done that in May. You could have done that in June. A conscious decision was made not to do that. Mr. Thompson says he's unsure as to what the FEA wants. You know what the FEA really wants? You know what the FEA really wants? They want respect. They want you to respect the contract that you agreed to, all its terms, all its conditions, not some, well, let's walk around it. Let's pull there's a word I'm not going to say. We're going to get some technicality and we're going to be out there when the expectation of the parties for the last 54 years was you negotiate with the FEA. You don't create this little exception that isn't provided for in the law. The legislature already provided you with exceptions. Take advantage of them.
Yes, Jim. Yeah, absolutely. Let's take a 5-minute break. Everybody's back in the room, so we'll continue with our hearing. Other questions? Yes, Greg?
So, are all parties in agreement that this position is not something that could be filled given the current negotiated agreement? Like, I'm thinking if we could have filled this position through the normal negotiated agreement, we would have done so 100 days ago. Are we in agreement on that?
That is my understanding of it, but that may be more appropriate for superintendent or.
I'll let Grant go first and then I can respond.
I'll distribute this policy document.
Thank you.
The policy that's distributed, Administrative Policy 5120, deals with the reassignment of staff. And to Greg's question, is there a way that the district could have filled this position? The answer is yes. This portion of the policy, my understanding is that Mr. Marquardt and Ms. Rigger, the former FEA president, have worked together with administration on drafting this language to provide some protection to teachers who were going for the all-for-one certification that was offered by the district. This says that the district may not involuntarily reassign certified staff who receive additional endorsements in the all-for-one to a full-time position in their new endorsement area without completing a comprehensive search process to fill the position and failing to find a successful candidate. So it says you can't reassign, but what it really means is you can reassign as long as some precautions have taken place first, a comprehensive search. It goes on to say this provision is not applicable to circumstances that warrant a reassignment for causes other than filling a vacant position. In situations after August 15th, the district must also demonstrate one of the following. There is a viable candidate pool to backfill the reassigned staff member's current assignment. Or two, there is the ability to distribute, eliminate, modify, or reassign the transferred staff member's original assignment to other staff members. So, Mr. Clark, your question, the answer is yes, there is a way. It's the reassignment of staff policy. And I think FEA, our position was pretty clear to members when this came about, because there was a concern that these kinds of reassignments might become necessary down the road. And so we made clear to members at the time, and we continue to make clear to members that if you had taken the all-for-one stipend to gain an additional endorsement, this is a distinct possibility, an involuntary reassignment. While I have the mic, I will speak into the record that it was June 21st that we signed through the negotiations process after significant discussion to pay SPED teachers an additional $6,000 for the 2023-2024 school year and the 24-25 school year. So if you do the math, June 21st to the date upon which you accepted the award of the bid, I believe that was July 11th, we're talking about 20-some days that the SPED stipend had gone into effect, had been signed. Of course, the contract is not finalized today, but the district nonetheless has begun advertising that. So there really was an opportunity here. The district didn't do that. They didn't take advantage of that. They didn't advertise that. There was an opportunity to say, hey, we've already negotiated with the representative organization to do additional pay for SPED teachers over the course of the next 2 years. Let's respect that and understand that it's working.
Okay.
Grant, I'm not sure we're in answer question mode right now, but thank you for your time. Dr. McKenna, did you have a,
If I may.
sure.
So when this position, one of our board members brought up, then why do we need to outsource this position? As was stated, and I'm sure viewable on the record, is our goal is to always hire internally in FPS. As of now, the position's been open for 144 days. We did email out all of our all-for-one special ed qualified staff members numerous times, talking about all of our special ed positions, inclusive of this one. We did do a social media blast to internal, external. I was on 2 radio shows talking about this supplemental pay. And while Grant is right, AP 5120 would give us the opportunity to reassign. Please don't mistake this as this is not just a regular special ed position. This is a level C position, and we've tried to have subs support the work. This is a tough gig for even well-qualified people. I do not want to use AP 5120 to take somebody and put them in a position that they're certified for, but maybe not qualified for. This is not just about supporting and differentiating instruction, doing accommodations. This is a tough gig. And so we have been trying. Our goal is to continue to try. We are going to be at a job fair at NDSU, I believe on Wednesday. We'll be there again in force. We are looking. I'm going to meet with Lisa Steiger at MSUM tomorrow at 11:30. We're trying to hire for these positions. We have to do what's best for our kiddos, and putting somebody that's certified but not qualified in this spot isn't fair to any of our FPS teachers. We called out to them numerous times. Nobody took us up on it. And, and that's why we're 144 days later, here's where we're at.
Okay, yeah, Robin?
So what and what this comes down to is requested remedies, and there are 3 that have been requested from the Fargo Education Association, and basically is to rescind the action when the board approved the hiring of this staff through the third party, and then support to the new memo recommendation to, again, rescind the action, and the board shall rescind the action taken on memo number 10 at the July 11th, 2023 board meeting. So those requests have been made, then what? Is my question. How do we fulfill this federal requirement?
Yeah, so I guess I'll just offer, I've been grappling with this a lot. I think that we could find that the contract was violated, but that the remedies sought aren't appropriate remedies. And I guess one question that I have, Dr. McCann, if you could walk me through why we didn't do the unfillable petition to DPI.
Yeah, I don't know how well I'll be able to walk you through that.
Okay.
I talked to Shelby and Missy about it when Dave had called and left me a message. I called him right back when it was on the board agenda. When I talked with them, it was an item that was on the agenda as well the year before and approved by the board without protest. So I really wasn't as familiar with this entire process with an unfillable position. I am now, but at the end of the day, I wasn't familiar with the position. I was at that board meeting that evening, but I think Dr. Gandhi might explain more of that.
Yeah, I can provide some clarity, and if there's any other cabinet members that want to chime in, feel free to do so. I think there's an important distinction here that needs to be made, that the administration's position was that we were never hiring or outsourcing a teacher that we could employ in-house. The uniqueness of this position is not only that it is a contract with full service who has been providing services for our students, specifically students on IEPs for some time. This service provider also happens to be certified to be able to provide academic instruction. It is not the district's intention, even if we continue and are able to employ someone and hire him to get rid of the contract, because we need that set of services from full service. So we have always approached this as a continued contract service provider in a situation that Full Circle just recently has also certified educators that can provide instruction. They're doing that, but this contract is not, we're not viewing this as contracting out a teaching job that we have employed in-house. I think to Greg's question earlier about wouldn't we do everything we could, we absolutely would. To the reassignment policy that was passed out, we have actually reassigned staff members that were special ed certification and then they left. So we have actual examples of documentation of in this last month of reassigning to fill special education positions. So I think it's important to know that this wasn't a carte blanche, go get teachers for every SPED classroom that we have available or every classroom that we have available. It was the uniqueness of this program and the set of services that the students require. Full Circle Solutions has been providing those services with our district in partnership for some time in a variety of ways. And the reality is that as we continue to approach cognitive needs for students, there is a gray area in what is an academic need versus what is a medical need. We've talked about that in the past with the board as well, especially when it comes to IEP services that they need, because just like physical health, there isn't the clear delineation of what is a medical service provider that's needed and what is academic instructional accommodation for students on an IEP. And that becomes more complex when you're talking about students that have these complex needs in a setting C classroom. That's why Full Circle is actually a service provider for wraparound services for students, and they're also able to provide academic services, and that's what's happening in this situation.
Well, I think we're at a kind of a crossroads here where we have an administration with legal counsel that believes they had the right to hire an independent contractor. And we have an association that believes hiring an independent contractor is the same thing as hiring a public employee. And I think Mr. Geierman said it right. He said this is a hair he's not going to split. Perhaps in the future it may have to be split by the court. But based upon the fact that I do believe we have the right to use an independent contractor, I'm going to make a motion that we find the FEA grievance submitted on August 28th to not be valid, and we support the decision that was made by Dr. Gandhi in his review of the FEA grievance.
Second. Actually,
Any discussion?
yeah.
Yes.
Just to start the discussion, I want to second, but I have a question too. Actually, a couple, and either for Jeff or Rupak. The teacher that has been that Full Circle is providing, that teacher is in the classroom currently, right now, providing education for a student.
Yes.
So my next question is, given that I'm gonna assume I know the answer to this, but if it's been this position's been open for 144 days, we've tried everything to fulfill it. We don't think as a district, or at least Jeff or administration doesn't feel that we may have certified staff to take care of this position, but not well-qualified staff for this position. I'm not trying to have a rhetorical question here, but what happens to those students if we get rid of this contract and we no longer have that teacher to provide that service for those students? What happens to those students?
We would have a group of students that wouldn't be getting the services that they need on their IEP. Now, IEP teams could reconvene and talk about different services, but it's important to know that within special education, teaching services are not just transferable when you're talking about special education services that Mr. Thompson has already alluded to that are federally required. And as I shared before, there's a difference between academic accommodations and also a set of services that we need to provide. When it comes to the field of special education on an IEP, a set of services could be your location, such as a setting C classroom, which is your time away from your least restrictive environment, or it could be a set of services as outlined through direct instruction, as outlined through a therapy provider, as outlined through whatever that need might be based on that student's disability. So if this individual were to be pulled out of the classroom, students would be lacking those services. And as I shared before, it has always been administration's intention to continue to try to find a permanent teacher that we can employ for that classroom. And should we do that, we are still planning to continue contracting with full service to provide those services for students too. It just happens to be that full service is able to provide academic services in addition to the true services that some of those students need based on what their IEP states.
Katie?
Are you done?
Yes, sorry.
Okay. It's okay. Dr. McCann, so you were speaking a little bit, I'm just curious, is the position still posted? So like if we found somebody who could, would we, I mean, if we have 30 days to end the contract, would we consider doing that and then hiring somebody to take that position?
Well, I'll just answer the first part and then I'll defer to Dr. Gandhi, because there are a lot of supplemental services that are provided. We are actively looking to fill every single position that we still have. And yes, it's posted and we are continuing to look for that position.
Thank you.
I do have a question because based off of what's all been said. So this individual in the classroom right now is providing not only classroom services, but wraparound care that that would violate the teacher's contract if he or she had to stay for, I don't know, like longer than the contracted day, or like this person is not just a classroom teacher.
Madam President, that is correct. We hired a set of services that was inclusive of academic services because it's being provided by someone that is licensed to do that in the state of North Dakota. I do know that our Assistant Director of Special Education is also on the phone, so if it's okay with you, she could provide more clarity because I know I've been saying services. I know that she can go granular.
I would appreciate that if she's.
Yes, hello, thank you. Madam President, can you hear me?
Yep, I can. Thank you. Please go ahead.
So through our contract with Full Circle Pediatrics, we are able to not only provide academic services, but through that contract, it also allows us to tap into their resources, which include board certified behavior analysts and registered behavior technicians to ensure that we are providing the services as outlined on the students' IEPs that are found within that classroom setting. And this allows us to ensure that we are providing academic services as well as behavioral services that supports the students as they are within the school day to fulfill those needs.
Thank you. Any questions based on that? Yes, Greg?
I have a unrelated question. Our GP2E says that we board members should be voting on every question that they have an opinion on. However, to me, this problem, this entire process seems to be kind of a legal gray area with independent contractors versus other routes that could be used to fill a position. And I'm fully willing to admit that I don't think I should be the person to render a legal decision on this instance. So I would politely ask to be able to not vote on this matter because I see it squarely and exclusively a legal position that I'm not qualified to render a decision on.
Yes, Jim?
Don't disagree at all, Greg, but unfortunately, you don't have a choice here. we have to respond, I believe, by tomorrow under the 20-day requirements that we have. And hence the reason I said Mr. Geierman didn't want to split hairs. I believe it'll be the FEA's decision to decide whether or not a court will decide this or not. But we have to make a decision. We can't choose not to act. At least I don't believe we can, and be in compliance with state law.
Yes,
Yeah, the only time that a board member can withstand from voting would be if you have a conflict of interest, and even in those regards, the board can vote to require you to vote anyway. The failure to vote will side with the majority.
Robin?
And Tara, that's a fiduciary. And that's a fiduciary conflict. That's disproportionate
Correct.
only, okay.
Nimal, I think I saw your hand up.
I know this might be redundant. I believe that every situation, there's always a cause and effect. One of the reasons why districts take their position to hire somebody. What I do not get is if the position has been there for 144 days, and this is where I kind of got confused a little bit, forgive me. Who was supposed to be responsible to hire those teachers? Is it the FEA or the districts? Because when you look at the way that I'm looking at it, our student come first. And don't get me wrong, we all see situation difference. For me is I'm here to support all the students at all district levels. And the fact that, we all are here today to talk about who should be doing the hiring and who shouldn't. And don't get me wrong, people analyze things different. Because to me, this is not where we should be arguing. We should be looking into how our student doing, how their grades are academic wise overall. That is where I come in as a board member because I need to oversee those things. My question is, as I said earlier, is who's supposed to be in charge? Because there's always a cause and effects on everything that we do in life, not only here, everywhere. Because there had to be a reason why the district took whatever they did, the decision that they took, for us to be in this position. Is it the fact that, they did not contact the DPI? Or is it the fact that, they decided they want to go out of their way to find somebody to fill this position? Because this, to me, does not make sense. Because at the end of the day, if we took that teacher out from their classroom, who's going to teach those kids? Who's going to be responsible for it? Are we just going to let them be just because we disagree on the contracts here? Because keep in mind, this is not about us anymore. This is about the students. To me, I come here for the students. So I hope we come up with some agreement here, because I don't want any kids to be left behind just because we disagree on something as an adult. Because to me, this is wrong. I understand, Madam President said, yes, we did violate some stuff, but what are our way to move forward? So we need to look into this a bit more. And I agree with what Jim said too as well. Thank you.
Could we restate the exact motion on the floor?
Yep, I think Jim wrote it down. If
Can you read it again?
yes, please.
I moved that we find the FEA grievance submitted on August 28th to not be valid and we support the decision that was made by Dr. Gandhi in his review of the FEA grievance.
All right, and if there's no further discussion, I think we'll be ready to take a roll call vote, please.
Clark,
Yes.
Day,
Yes.
Gullickson,
Yes.
Holden,
Yes.
Johnson,
Yes.
Nelson,
Yes.
Newman,
Yes.
Christensen,
Yes.
President Berkland.
Yes. Okay, motion passes. And we are adjourned.